Welcome back to the Deep Dive. This is the place where we tackle, well, really dense source material, like statutory text, that, let's be honest, most people just skim or skip entirely.
Right.
And we try to turn it into clear knowledge you can actually retain. Today, we're taking a pretty necessary descent into the absolute bedrock, really, of the legal system. We're talking about the general provisions of state criminal law.
That's exactly right. When you think about criminal law, your mind probably jumps to the big stuff, the drama of major cases, theft, murder, maybe financial crimes.
Sure.
But none of those laws really function in a vacuum. They're all built on this core philosophy, the specific vocabulary, and importantly, the jurisdictional limits defined right there in Chapter 1 of the state's Penal Code, this chapter. It's basically the instruction manual. It dictates how the whole system behaves.
So our mission today is explicitly for you, the learner. We're taking these introductory parts, sections 1.01 through 1.0, and we're going to try and transform that sometimes overwhelming statutory language into clear, memorable concepts, things you can actually use.
We're decoding the state's intent.
Exactly. Focusing on teaching this comprehensively, making sure you walk away, understanding why these structures are even there.
Yeah, and we could probably start by just getting the quick housekeeping out of the way. Section 1.01, it's purely administrative. It just says, this code shall be known and may be cited as the Penal Code.
Okay, simple enough.
No surprises there. And Section 1.06, which deals with computation of age, clarifies something that's actually pretty important in juvenile cases or competency hearings. It says a person hits a specified age on the day of the anniversary of their birthday.
Ah, so not the day before. You turn 18 right when the clock strikes midnight on your 18th birthday.
Precisely. Simple, maybe, but legally crucial for deciding which court has jurisdiction.
Okay, let's unpack this a bit then. Before we even define what a crime is, we really need to get why the system exists in the first place. What's the foundational purpose? Section 1.02, the Objectives of Code section, lays out 6 core goals. And the overarching aim, it says, is to establish a system of prohibitions, penalties, and correctional measures to deal with conduct that unjustifiably and inexcusably causes or threatens harm. But that very first objective, it's huge. And honestly, maybe a bit contradictory.
Oh, it absolutely is.
Right.
The first objective is ensuring public safety. But the code doesn't just leave it at that, like some vague idea. It actually breaks public safety down into 3 distinct and often competing philosophical goals. It's what we sometimes call the triple threat of criminal justice.
The triple threat. Okay, I like that. What are these 3 mandates the state is trying to juggle?
Well, they're listed right there as A, B, and C. First, A is the deterrent influence of penalties.
Okay, deterrence.
Right. This is the classic idea that the system stops future crime by making the cost of committing the offense just too high. It's about stopping the crime before the impulse even turns into action. The penalties have to be severe enough, theoretically, to make people think twice.
Makes sense. What's B?
Second, B, is the rehabilitation of those convicted of violations. This is the restorative justice angle, trying to change the individual's behavior, their mindset, so they can function okay in society and, hopefully not reoffend, reducing recidivism.
And the third part of the threat?
And third, C, is punishment necessary to prevent likely recurrence of criminal behavior. This is classic incapacitation. If someone is clearly dangerous, well, public safety is served by containing them, usually locking them up so they can't harm the public while they're incarcerated.
What's really striking here is that the code actually mandates trying to do all 3. If you listen to legislative debates today about, say, mandatory minimums or bail reform or funding for rehab programs, you're basically listening to people argue about how to prioritize these 3 goals, and they often seem like they're fundamentally at war with each other.
That is the core conflict. It really is. If you lean too heavily on deterrence and incapacitation, you tend to get these long, really inflexible sentences, and that often just kills any motivation for rehabilitation.
Right.
But if you swing too far the other way, towards rehabilitation, critics will jump up and say, you're sacrificing the punishment needed for deterrence and, well, immediate public safety. The code. It doesn't pick a side. It demands this kind of impossible balancing act from judges, from correctional facilities, right from the get-go. It basically enshrines that internal philosophical tug-of-war as the permanent mission.
Wow. Okay, so that brings us to goal number 2, fair warning. This sounds like it touches on constitutional stuff like due process, making sure people know what they can and can't do.
Precisely. The objective says that through the definition and grading of offenses, the code has to give fair warning of what is prohibited and of the consequences of violation.
Meaning the language has to be clear.
Super clear.
Yeah.
Precise, unambiguous. You need to know that this specific action is banned, and if you do it, you're going to face this specific consequence, a Class C misdemeanor, a second-degree felony, whatever grade it is.
Yeah.
If a law is so fuzzy that a regular person can't figure it out, it violates this basic objective.
So the clarity itself is the due process.
It really is. Okay, next up is Goal 3. This one looks at both the crime and the person who committed it. Proportionality and rehabilitation recognition.
Proportionality, what does that demand here?
It's simple on its face, but absolutely crucial for a just system. To prescribe penalties that are proportionate to the seriousness of offenses. Basically, the punishment has to fit the crime.
Right.
This objective is pushing back against, draconian penalties for minor stuff. But the second part is just as important. It says the system must permit recognition of differences in rehabilitation possibilities among individual offenders.
So this is where judicial discretion really comes into play, looking at the individual, not just the offense category.
Absolutely. Think about it. Two people might commit the exact same crime, let's say low-level theft, but one might be a, career criminal who's resisting any change, and the other might be a first-time offender, maybe driven by some extreme situation with real potential to turn things around. This objective requires the system to see that difference. The crime might set the maximum possible punishment, but the individual's potential for rehab should shape the actual sentence given.
So justice isn't totally blind in the sense that it ignores the potential future path for the specific person standing in court?
No, it actually mandates an individualized look.
Okay. Goals 4 and 5 seem to shift focus a bit, less on the convicted person and more on the state itself, keeping things fair and limiting power. Safeguarding the innocent and limiting official discretion.
Yeah, Goal 4 is like the state's promise to people who haven't done anything wrong, to safeguard conduct that is without guilt from condemnation as criminal. It's an explicit defense of just, living your life lawfully, making sure the state doesn't write laws so broadly that they accidentally criminalize everyday, perfectly legitimate behavior.
And Goal 5, limiting discretion. That sounds like a direct check on potential abuse of power by officials.
It's the civil liberty safeguard baked right in. It aims to guide and limit the exercise of official discretion in law enforcement to prevent arbitrary or oppressive treatment of persons suspected, accused, or convicted of offenses. Think about it every single day. Police officers, prosecutors, they make decisions involving huge power imbalances. This objective is the law basically demanding that the code itself must be written clearly enough to stop police from, say, randomly arresting people or prosecutors from filing charges based on bias instead of the actual law. It sets the boundaries, the rules of engagement for everyone working for the state.
And the last one, Goal 6, is about defining the state's turf, systematizing jurisdiction.
Exactly. It defines the scope of the state's interest in enforcing laws against specific crimes and basically organizes how and when the state can actually prosecute someone, which leads us perfectly into how the state actually enforces this whole system.
Right, so we're moving from the why, the philosophy, to the more practical how. This next part seems to establish what actually counts as a crime and, critically, who gets to enforce it, how that power is distributed.
The foundational principle is laid out right away in Section 1.03a. Conduct isn't a crime unless it's actually written down as one. It says conduct does not constitute an offense unless it is defined as an offense by statute, municipal ordinance, order of a county commissioner's court, or rule authorized by and lawfully adopted under a statute.
So if the legislature or a local government that the legislature gave power to hasn't passed a specific law defining it, it's not a crime, period.
Exactly. No secret, unwritten common law crimes floating around. It has to be explicit.
Okay. Now, subsection B here. This seems to be where the Penal Code really shows. It's like the universal operating system for all the other state laws out there.
That's a perfect way to put it. Section 1.03b makes it clear that the introductory titles 1, 2, and 3, which cover the general principles, culpability, or mental states, and punishments, they apply even to offenses defined outside the Penal Code itself.
Like, say, in the state's health code, which might define crimes related to dumping medical waste.
Boy.
Or the tax code defining tax evasion.
Exactly, those kinds of things. So if the health code makes improper medical waste disposal illegal, the Penal Code doesn't define that specific offense. But Chapter 1 here tells us, it tells us where the state can prosecute it. That's jurisdiction, which we'll get to. And it tells us what the required mental state, like knowing or intentional, has to be to prove the crime, unless that other specialized code, like the health code, defines a different mental state itself. The Penal Code provides the standardized framework for how you prove a case and run a trial, even if the specific crime definition lives in a whole different book of statutes.
Got it. Now, let's talk about this civil-criminal divide in 1.03c. For someone not steeped in law, this can be really confusing. Why can someone be prosecuted and sued for the same thing?
This is the critical non-merger rule. It clearly states that the Penal Code doesn't bar, suspend, or otherwise affect a right or liability to damages, penalty, forfeiture, or other remedy authorized by law to be recovered or enforced in a civil suit. The key thing for you to grasp is that criminal consequences, think prison time, fines paid to the state, are totally separate from civil consequences like damages paid to the victim.
So, using an example, if I get mugged, the state prosecutes the mugger for the crime of assault, maybe robbery. But I can also separately sue that same mugger for my medical bills, maybe lost wages, pain, and suffering.
Exactly. You often get two bites at the apple, legally speaking, because the burden of proof is completely different in the two systems. In the criminal case, the state has to prove guilt beyond a reasonable doubt. That's a very, very high standard because someone's liberty is on the line.
Makes sense.
But in your civil lawsuit, you only need to prove liability by a preponderance of the evidence. That just means it's more likely than not, think 51%, that the defendant caused your harm. Because that standard is lower, you can absolutely see situations where a defendant gets acquitted in criminal court but still gets hit with massive financial damages in civil court for the exact same actions.
That clarity really helps understand why we sometimes see these parallel legal tracks running.
Yeah, it's the fundamental difference between punishment by the state and compensation for the victim.
Okay, moving on. Next, we see the state kind of asserting its dominance over local rules. This is preemption in Section 1.08. What's the thinking behind stopping local governments from making up their own criminal rule?
Well, this ties right back to goal number 2 we talked about, fair warning, and also goal 6, systematization. Section 1.08 says it very clearly. No governmental subdivision or agency may enact or enforce a law that makes any conduct covered by this code an offense subject to a criminal penalty.
So it centralizes things.
It centralizes criminal lawmaking at the state level to prevent just a chaotic patchwork of laws across different cities and counties.
So if the state penal code already covers something, let's say public intoxication, a city can't just create its own separate ordinance that defines public intoxication differently or maybe slaps a harsher penalty on it?
Correct. The goal is uniformity. You want the law to mean the same thing whether you're in El Paso or Houston. If every little town could create its own unique felonies or conflicting misdemeanors, the whole system of classifying crimes and sentencing would just fall apart. It would completely undermine those statewide objectives we started with.
Makes sense. Now, while local governments are restricted, the state attorney general is given some specific power here, concurrent jurisdiction in Section 1.09. But it sounds like the AG's power to jump into a local prosecution is pretty limited.
Extremely limited.
Yeah.
And it seems clearly designed just to protect the state's own money and property interests. The AG only gets this concurrent jurisdiction if two specific conditions are met. First, the crime itself has to specifically involve state property. And that includes state funds, or some element of the offense has to happen on state property.
Okay, so we're talking about things like theft from a state university or maybe fraud involving state grant money.
Exactly that kind of thing. But what's the second condition? And this one's arguably even more critical.
Well, me.
The Attorney General needs the express consent of the local county or district attorney who would normally handle the case.
Ah, so that's a major check.
It's a crucial check. The state basically reserves primary prosecution power for almost all crimes to the local DAs, who are usually elected officials. The AG can't just swoop in and take over a local case, even if state money is involved, unless that local elected prosecutor agrees to share the authority. It maintains respect for the local democratic process and stops prosecution decisions from becoming too centralized at the state level.
Okay, that structural setup, how power is shared or limited, that lets us now sort of map the boundaries. Section 1.04 defines the geographical reach of the state's criminal power, territorial jurisdiction.
Yeah, this is one of the most critical sections, honestly, for understanding how the state can prosecute crimes that cross borders or are just really complex logistically. The core rule in 1.04A1 is actually pretty elegant and simple. The state has jurisdiction if either the prohibited conduct the actual act or a result that is an element of the offense happens inside the state.
We should probably spend a moment clarifying that difference between conduct and result with some practical examples. That could be tricky for the learner.
Good idea. Let's use, say, a digital crime. Imagine someone is sitting in Louisiana outside the state, And from there, they execute some sophisticated financial fraud. They're wiring money, setting instructions. That's the conduct.
Okay, conduct happens outside.
Right. But the actual result, the victim's bank account being drained, the illegal withdrawal itself happens at a bank in Dallas. In that case, the state has jurisdiction because the result, which is a key element of the fraud offense, occurred inside the state.
Got it. And the reverse.
Conversely, let's say someone commits an act of attempt, that's the conduct inside Austin. Maybe they're gathering tools for a burglary, but the place they were planning to burglarize was actually over the border in Oklahoma. The state still has an interest and jurisdiction because the criminal act started here.
So the extraterritorial reaching beyond state lines, is based on that direct connection back to the state. And the state can also prosecute conduct that happens entirely outside the state in two classic legal situations: attempt and conspiracy.
Right. For attempt, which is 1.04A2, the state can prosecute conduct outside the state if it constitutes an attempt to commit an offense inside the state. So if you plan a robbery and gather your tools in Arkansas, but the target is a store down in San Antonio, that preparation, even though it happened elsewhere, establishes your intent and connects legally to jurisdiction here.
Okay, that makes sense for attempt. What about conspiracy?
Conspiracy under 1.04A3 is just a little bit stricter. The conduct outside the state has to be a conspiracy to commit a crime inside the state, and this is the key part. There must be an act in furtherance of that conspiracy that happens inside the state.
Can act in furtherance, that's the legal hinge then.
That's the hinge. It could be something as simple as sending a text message to a lookout who's already inside the state, or maybe depositing a small amount of seed money into a local bank account. That single action, however small, can be enough to pull the entire conspiracy, including the members who never physically crossed the state line under state jurisdiction.
Wow. Okay. And what about this reverse jurisdiction thing in 1.04A4? This is where conduct inside the state helps a crime happen somewhere else.
Yeah, this covers situations where someone inside the state does something like soliciting someone to commit a crime, conspiring with others, or aiding a crime that's linked to an offense committed in another state or country. The key limitation, though, is that the crime committed elsewhere must also be a crime under this state's laws.
Oh, okay.
We're not going to prosecute someone here for helping someone do something in, say, Mexico, if that action's perfectly legal here. It preserves our own state's definition of what's criminal, while still asserting jurisdiction over people who operate from within our borders to facilitate crime in other places.
Makes sense. Let's pivot now to the special rules just for homicide in Section 1.04. Death cases often seem the most complex when it comes to figuring out where things happened.
They often are, and homicide gets special treatment in the statute for that reason. First, the result in a criminal homicide case is defined as either the physical impact that causes the death or the death itself. But the most powerful tool here for prosecutors, especially in murky cases, is this crucial presumption. If the victim's body is found in the state, it is legally presumed that the death also occurred in the state.
Whoa, that presumption sounds like a huge deal for establishing jurisdiction, especially when the circumstances are unclear, like maybe a body is dumped just over the border or found in a remote field somewhere.
It's massive. It effectively shifts the burden. The prosecution can point to the body's location here to establish jurisdiction, and then it's up to the defense team to try and prove otherwise.
Is there a check on that, though?
There is an important defense built in. If the only connection to the state is that the person died here, meaning the conduct, the act that caused the death, happened somewhere else, it's a defense to jurisdiction if that conduct wasn't criminal in the place where it actually occurred. It's a crucial protection against jurisdictional overreach.
Okay. And finally, 1.04C and D seem to define non-physical acts and the physical extent of the state's boundaries.
Right. Subsection C deals with omissions. If the crime involves a failure to do something that a state law requires you to do, like maybe failing to file a mandatory regulatory report, the offense is considered committed inside the state no matter where you physically were when you failed to do it. The legal duty itself anchors the jurisdiction here.
Got it.
And subsection D is straightforward but important. The state's boundaries include the land, the water, and crucially, the airspace above them. It asserts state criminal control over pretty much everything within its physical and vertical limits.
All right, we've covered the why, the philosophy, and the where, the map of jurisdiction. Now we get into the what, the actual vocabulary. Before we dive into all the specific definitions in Section 1.07, we absolutely have to start with Section 1.05, construction of code. This is like the official interpreter's guide for the whole thing, right?
It is, and it offers a major insight into how the state views its own criminal laws. Traditionally, going way back, penal statutes were always strictly construed. That meant if there was any ambiguity in the law's language, courts had to read it narrowly, usually in favor of the defendant. Section 1.05a explicitly throws that old rule out for this code.
So no getting off on technical loopholes by default anymore. What's the new directive then?
The directive is that the provisions of this code shall be construed according to the fair import of their terms to promote justice and affect the objectives of the code. This is basically a command to the courts. Interpret the law broadly, constructively. Every time a judge looks at a statute, they're told to prioritize achieving those 6 big objectives we started with: public safety, deterrence, proportionality, all that, over finding some technical ambiguity that just happens to benefit the defendant. It's a fundamental shift from how law was often interpreted classically.
That's a really significant shift. Okay, excellent. Let's jump into the essential definitions in Section 1.07 now, starting with the 3 basic parts of almost any crime: act, actor, and conduct.
Okay. Act under 1.07 is defined pretty broadly. It's a bodily movement, whether it's voluntary or involuntary, and importantly, it includes speech.
Speech can be an act.
Yes. Actor 1.072 is just the person whose criminal responsibility we're talking about, the suspect, the defendant. But the concept we really need the listener to lock onto is conduct, defined in 1.07. Conduct is the whole picture required for almost every crime. It's an act or omission and its accompanying mental state.
Okay, so when a law says a person has to engage in criminal conduct to be guilty, that's really shorthand. It means the prosecutor has to prove both the physical action or the failure to act, and they also have to prove the required mental state like intent or knowledge or recklessness that went along with it.
Precisely. It inherently ties the physical event to what was going on in the actor's mind at the time. You need both.
Okay. Moving to defining harm. Harm itself in 1.07 to I5 seems incredibly expansive.
It is. It defines harm as basically anything reasonably seen as loss, disadvantage, or injury. And crucially, it specifically says this includes harm to another person in whose welfare the person affected is interested.
So that allows the law to recognize indirect harm, like the emotional pain or financial loss suffered by a victim's family member.
Exactly. It helps define the full scope of the damage caused by the criminal offense, beyond just the immediate victim.
Now, here's where I think it gets really interesting and critical for understanding charges. Comparing the different levels of physical harm, specifically bodily injury versus serious bodily injury, this distinction feels like the legal cliff edge between maybe a lower-level misdemeanor assault and a really severe felony charge.
Understanding this difference is absolutely paramount. Bodily injury, defined in 1.078, means simply physical pain, illness, or any impairment of physical condition. The threshold here is remarkably low.
How low?
Think about it. A slap that stings, a hard shove that causes someone to stumble, even just the momentary physical pain from being punched, that's enough to satisfy this definition. It doesn't require a broken skin, a doctor's visit, or any lasting marks.
Wow. So just feeling pain is legally sufficient to meet the requirement for, say, assault causing bodily injury.
Yes. Now, contrast that with serious bodily injury, defined way down to 1.0746. This is a whole different level. This is injury that creates a substantial risk of death or causes actual death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ.
Okay, so now we're talking broken bones, needing surgery, serious head trauma, losing your sight, scars that permanently change how you look.
Exactly. That's the level. And that difference in definition, that's often the difference between facing maybe some county jail time for a misdemeanor versus potentially a decade or more in state prison for a felony.
That clarity is just essential. Let's apply that severity distinction now to the definition of deadly weapon in 1.0717. Seems like that's also split into 2 different ways something can qualify.
It is. It's bifurcated. It covers both the object's design and the context of how it's used. Part A covers the obvious stuff. Items manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury. Think your traditional firearms, daggers, brass knuckles. They're deadly weapons just by their nature.
Okay, the inherently dangerous stuff.
Right. But Part B is the really expansive part. It covers anything, literally anything, that, in the manner of its use or intended use, is capable of causing death or serious bodily injury.
Okay, wait, so this means a completely ordinary, everyday object like, I don't know, a heavy book, a lamp, even a glass bottle can suddenly become a deadly weapon in the eyes of the law, purely based on how someone uses it or intends to use it in that specific moment.
Exactly right. Think about a tire iron sitting in your trunk. It's just a tool. But if you pull it out during a fight and swing it at someone's head, you have just transformed that tool into a deadly weapon as used. This expansion allows the law to address the potential lethality of someone's actions, regardless of what the object was originally made for. It focuses on the potential for serious harm in that context.
That's a powerful distinction. We should also quickly cover the basic offense categories: felony and misdemeanor.
Sure. Felony, under 1.0723, is any offense designated as such by law, or one that's punishable by death or by confinement in a penitentiary, that's the state prison system. A misdemeanor, 1.0731, is designated by law or punishable by a fine, confinement in jail, that's the local county system, or maybe by both. That distinction between penitentiary and jail is key state versus local lockup.
Got it. And finally, in this section of foundational vocabulary, we really need to address the specific definitions concerning human life, particularly regarding the unborn, in 1.0726 and 49.
Yes, Section 1.0726 makes a very specific statement about the scope of legal protection. It defines individual as a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth.
So a very comprehensive definition.
Extremely comprehensive. It effectively grants the unborn child, right from fertilization, the full legal status of an individual under the Penal Code, meaning offenses against the person can apply. And Section 1.0749 reinforces this. It states that death, when talking about an individual, includes, for an unborn child, the failure to be born alive. This is the statute providing clear definitions for offenses that might involve harm during pregnancy.
Okay, continuing our deep dive into the vocabulary, let's focus now on terms around state of mind, agreement, or lack thereof, and specific kinds of threats.
Right. As we touched on, conduct requires proof of a culpable mental state. Now, the really detailed definitions of the four main levels, criminal, negligence, intentional, knowing, and reckless, they're actually in a later chapter, Chapter 6, specifically Section 6.03, which is cross-referenced here in the definitions.
But the key takeaway for now is
the key thing to remember is that proving one of these mental states is the prosecutor's job for almost every significant crime. You generally can't commit a crime by pure accident, with no culpable mental state at all, unless the law very specifically defines it as an offense of strict liability or maybe criminal negligence, which is itself a defined mental state.
Got it. Now, let's focus heavily on consent, and specifically the nuances around effective consent. It feels like in many crimes, theft, assault, sexual offenses, proving the absence of effective consent is basically the entire case.
It often is.
Yeah.
Consent itself, defined in 1.07, is pretty simple. It's just assent in fact, whether express or apparent. Someone agrees, either by saying so or acting like they agree. But the law is really concerned with effective consent, defined in 1.07. This includes situations where consent is given by someone legally authorized to act for another, like a parent consenting for a child or a guardian for a ward. But the most crucial legal lesson here, the thing you really need to retain, is the list of situations where consent is specifically vitiated, meaning even if someone seemed to agree, the law says that consent doesn't count. It's not effective.
Ah, the exceptions. These seem like the legal guardrails protecting vulnerable people and maybe protecting the integrity of law enforcement too. What are the exceptions related to the victim's ability to consent?
Okay, first, consent is ineffective if it was induced by force, threat, or fraud. Pretty straightforward. If you scare someone into agreeing or trick them, their yes doesn't count legally.
Makes sense.
Second, it's ineffective if it's given by someone the actor knows doesn't actually have the authority to give consent for the property or interest involved, like getting permission from a random stranger to borrow your neighbor's car.
Right.
Third, and this is a major protection, consent is ineffective if it's given by someone who, because of their youth, or a mental disease or defect or intoxication, is known by the actor to be unable to make reasonable decisions about the matter.
Okay, that is a critical point. The legal shield of they consented just dissolves if the defendant knew the person agreeing was too young or too impaired or too intoxicated to actually understand what they were agreeing to. The focus shifts to the defendant's knowledge of that incapacity.
Precisely. The burden is on what the actor knew or reasonably should have known about the other person's state. And the fourth exception, as you hinted, protects the state's ability to investigate crime. Consent is not effective if it was given solely for the purpose of detecting the commission of an offense.
This sounds like the legal basis for undercover stings. How does that work in practice, if an officer pretends to agree?
That's exactly what it's for. If an undercover police officer poses as a buyer and agrees to purchase illegal drugs, or maybe consents to receive stolen property in a sting operation, their apparent agreement is legally nullified by this provision. Why? Because their sole purpose in agreeing was to detect the crime. It prevents the defendant from turning around and arguing, hey, the officer was a willing participant, they consented. It ensures the state can prosecute the underlying crime without getting tripped up by the technicality of the undercover officer's feigned agreement.
Fascinating. Okay, let's move to coercion, defined in 1.0799. This definition seems to lay out exactly what kinds of threats count as legally coercive, and it looks like it goes way beyond just threats of physical violence.
Oh, much broader. Coercion is defined as a threat, however it's communicated, that involves one of 6 very specific types of prohibited actions. Yes, it includes the obvious ones like threatening to commit an offense, that's A, or threatening future bodily injury, that's B. But the definition is also really aggressive in protecting reputation and financial stability.
Okay, tell us about those reputational or financial threats.
Well, we have 3 distinct categories there, C, D, and E. Threatening to accuse someone of any offense, true or not, that's C, that's your classic blackmail scenario.
Right.
Threatening to expose someone to hatred, contempt, or ridicule, that's D. This recognizes that character assassination can be incredibly damaging, even if you're not accusing them of a specific crime. And threatening to harm the credit or business reputation of any person, that's E. This acknowledges just how devastating financial threats can be in our modern economy.
So the law is explicitly recognizing that non-physical threats can be just as coercive, just as damaging as a physical threat might be.
Exactly. It broadens the scope of protection. And the final type of prohibited threat, F, involves public officials. Threatening to take or withhold action as a public servant, or threatening to cause a public servant to take or withhold action. This is the legal shield against using threats to improperly interfere with government duties or, unduly influence public processes.
Okay. Before we move to our final section, let's quickly touch on a relatively recent addition, the specific statutory definition of mass shooting in 1.0730A.
Yes, this is a definition primarily designed, it seems, for statistical tracking and potentially for applying certain specialized laws or penalties. It's defined as a person discharging a firearm to cause or attempt to cause serious bodily injury or death to 4 or more persons.
4 or more.
4 or more. And importantly, the statute clarifies this can happen either during the same criminal event or during different transactions, but as part of the same overall scheme or course of conduct.
So that structural definition prevents someone from potentially avoiding the label just by, say, moving to a second location quickly if it's part of the same plan.
Exactly. It connects the underlying planning or scheme to the total result, even if chronologically separated. And one last definition we should clarify for context is public servant. 1.0741. This is a surprisingly broad category.
Broader than just police officers or elected officials.
Much broader. Yes, it includes officers, employees, agents of government at all levels. But it also includes jurors, grand jurors, arbitrators, mediators, even candidates for public office, and significantly, attorneys and notaries public when they are performing a governmental function. This wide definition ensures that the integrity of almost every stage of governmental or judicial processes gets legal protection under the code.
Okay, we started this deep dive with the state's broad philosophy of justice, and we seem to be ending with a very clear, very specific statement about political and legal boundaries. Section 1.zen, which looks like a more recent addition, is highly specific. It dictates exactly how state and local government entities are supposed to interact with federal firearm regulations.
That's right. This section essentially establishes a principle of non-cooperation, seemingly designed to assert state sovereignty specifically in the area of firearms regulation. The general prohibition is in 1.10b. It states flatly that state agencies, political subdivisions, think cities, counties, or their employees cannot contract with, nor can they provide assistance to, a federal agency for the purpose of enforcing a federal statute, order, rule, or regulation related to firearms if, and this is the key part, if that federal law imposes a restriction or prohibition that does not already exist under state law.
The implication seems crystal clear. State and local governments here are forbidden from becoming essentially agents of the federal government when it comes to enforcing federal gun laws that the state itself hasn't adopted.
That is the core mandate. And the section doesn't stop there. It then goes on to list 5 very specific types of federal restrictions that state and local entities are explicitly forbidden from helping to enforce. This list reads almost like a snapshot of ongoing national legislative debates around gun control.
Let's focus on the principle behind those 5 areas. What specific kinds of federal actions are state and local agencies barred from assisting with here?
Okay. They are prohibited from assisting with federal enforcement related to
Yeah.
A. Any requirement for a registry of firearms, accessories, or ammunition. B. Any requirement for an owner to possess a license simply to own, possess, or carry a firearm or ammo.
Mm.
C. Any requirement for a background check specifically for the private sale or transfer of a firearm where no licensed dealer is involved. D. Any program designed for confiscating firearms from a person who is not otherwise prohibited by state law from possessing them. And E. Any program that requires an owner to sell their firearm, essentially, mandatory buyback programs.
Wow.
This entire section is a very specific, very detailed assertion of state control over firearms policy within its borders, and it uses the foundational penal code itself to draw that line.
That is an incredibly specific delineation of power written right into the introductory chapter of the entire criminal code.
Makes it pretty hard to miss. And it's worth noting, it's not retroactive. Section 1.10c includes a grandfather clause. It says this whole prohibition does not apply to contracts or assistance agreements that were already in effect back on January 19, 2021.
Okay. So if a city or a county does violate this non-cooperation mandate, what happens? What's the enforcement mechanism here?
The enforcement is primarily financial and somewhat decentralized. First, there's a potential financial consequence laid out in 1.10d. A political subdivision, again, city or county, can actually lose state grant funds if a court determines they are actively requiring or assisting with the forbidden federal enforcement. That's the state wielding its power of the purse to ensure compliance locally. A powerful check.
Yeah, losing state funds would be a massive incentive for any local government to comply.
Absolutely. Second, enforcement can actually be triggered by ordinary citizens. Any individual who lives in that jurisdiction can file a complaint directly with the state attorney general if they offer evidence they believe supports the allegation that the local entity is violating this section. That's 1.9e.
So it empowers individuals to act as watchdogs.
It does. And if the AG investigates and agrees with the complaint, they can then file a petition in district court seeking what's called mandamus or other equitable relief to basically compel the local entity to comply with the law, and the AG can recover reasonable expenses for doing so. That's 1.10f. The whole structure sets up the Attorney General as the primary defender of this specific state boundary against federal overreach, as defined by the legislature here.
We have covered a remarkable amount of foundational legal ground today. I mean, we started with the deep philosophical objectives for an entire justice system, and we ended with these incredibly specific mandates about federal cooperation on one particular issue.
Yeah, to quickly summarize the absolute key takeaways for you, we established that the whole system is built on this inherent tension, right, between deterrence, rehabilitation, and incapacitation, and that the code itself must be interpreted to promote justice, not strictly construed against the state. We clarify that crucial difference between bodily injury, which can just be pain, and serious bodily injury involving risk of death or serious impairment.
Right.
And we saw how even an ordinary object's use can define it as a deadly weapon.
We also mapped out the state's really broad territorial reach, showing jurisdiction can attach if either the conduct or the result happens here. And we learned how those specific legal exceptions around effective consent work, both to protect vulnerable people and also to make things like undercover police work legally possible.
Absolutely. If you understand this chapter 1, you really now have the language, the operating system for the entire criminal code, every definition that follows, every specific crime, every punishment, and all flows directly from these core principles we've unpacked today.
Which leads us perfectly to our final provocative thought for you, the listener, to mull over. We've seen that the state explicitly says its penal code must be construed to promote justice and affect the objectives of the code. So, given those deep-seated objectives we started with, deterrence, rehabilitation, and proportionality, how do the specific, sometimes very technical definitions we analyzed today, particularly things like the jurisdictional rules or those explicit limits on cooperation with federal firearms enforcement, how do those technical rules ultimately reinforce or maybe even challenge those big overarching philosophical goals? Does the state prioritizing its own sovereignty in that specific firearms area, for instance, ultimately help or hinder its stated mission of ensuring universal public safety and justice for everyone within its borders?
Yeah, something to definitely think about. It makes you realize that even the sometimes dry language of statutory definitions is actually the engine driving some really high-stakes public policy decisions.
Absolutely. Well, thank you for joining us for this essential deep dive into the foundations of state criminal law. We really hope this knowledge sticks with you.